The Supreme Court just handed down a ruling that is going to change the way millions of gun owners think about traffic stops forever. 9 justices, 0 dissent, complete agreement. And what they ruled on is not some fringe legal theory or a technicality that only matters to lawyers. It is something that could happen to you the very next time you get in your car with a firearm. Now, I know what you are thinking. You have your permit, you know your state laws, you follow the rules, you are a responsible, law-abiding gun owner. So what could this ruling possibly mean for you? Because what the Supreme Court just clarified does not just protect people who break the law. It specifically protects people who follow it, people exactly like you. And if you drive a car and carry a gun, which describes most of the people watching this right now, then what I'm about to break down in the next few minutes could be the difference between knowing your rights and losing them at a car window. Think about what a 9-0 ruling actually means. These are 9 justices who disagree on almost everything, from environmental regulations to executive power to the shape of federal authority. When all 9 of them stand together with a single unified message, the entire judicial system has to sit up and take notice. There are no dissenting opinions to hide behind. There are no competing legal philosophies dividing the bench. When that happens, the legal answer was not close. It was clear, and the lower courts had gotten it fundamentally wrong. Before we get into it, hit that subscribe button right now. I know everyone says that, but here is the reality. Gun laws and court rulings are changing faster right now than at any point in the last 30 years. Most gun owners find out about decisions like this one not from educational resources, but from a cop at their car window. Or worse, from a public defender after they have already been arrested. I do not want that to be you. Subscribe, turn on your notifications, and let us get into this. To understand what the Supreme Court just decided, you need to understand the case that forced them to decide it. And this one starts in a way that is going to feel very familiar to a lot of you. A man, we will call him Daniel, was driving through a residential neighborhood in Texas on a Tuesday afternoon. He had a valid concealed carry permit. His firearm was holstered, properly secured, completely legal under state law. He was not speeding. He was not swerving. He was not doing anything that would normally draw police attention. Then he came to a stop sign. He rolled through it. Not a full stop, a rolling stop, the kind that probably half the drivers in America do every single day without thinking about it. An officer clocked it and pulled him over. Daniel did everything right. Both hands on the wheel, engine off, music down. When the officer approached the window, Daniel reached for his driver's license and his carry permit at the same time and handed them both over together. He said clearly and calmly, "Officer, I want you to know I have a concealed carry permit and there is a firearm in the vehicle, holstered on my right hip. Honest, cooperative. Exactly what responsible gun owners are trained to do." Now here is where you would expect this to go one way. The officer runs the information, confirms everything is legal, writes a ticket for the rolling stop, and everyone goes home. The officer asked Daniel to step out of the vehicle. Officers have the legal right to ask you to exit the car during a stop. That part was fine. But then the officer reached over and removed Daniel's firearm from his holster. He walked it back to his patrol car. He put it in the trunk. And then he told Daniel to stand at the rear of his vehicle and wait. Daniel waited. 5 minutes, 15 minutes, 20. At the half-hour mark, a second patrol unit arrived. At 40 minutes, a third officer showed up. They searched Daniel's vehicle. They went through his center console, his glove box, his back seat. They found nothing illegal because there was nothing illegal. Daniel's car was clean. After 45 minutes on the side of a Texas road, disarmed, away from his vehicle, without being charged with anything, Daniel got his gun back, got a ticket for the rolling stop, and was told he could go. He went. And then he called an attorney. Because what happened to Daniel happens to thousands of legal gun owners across this country every single year. You disclose that you are legally carrying, and suddenly a 2-minute traffic stop becomes a 45-minute ordeal. Your property gets taken without cause. Your stop gets extended without cause. And the entire justification is simply, he had a gun. Daniel's case worked its way through the lower courts, and eventually it made it all the way to the Supreme Court of the United States. To understand why this case mattered so much, you need to understand the massive constitutional collision that had been building in our judicial system long before Daniel's traffic stop. We are talking about 2 fundamental pillars of the United States Constitution working against each other in the hands of lower courts, the Second Amendment and the Fourth Amendment. The Second Amendment says you have the right to keep and bear arms. That right does not stop at your front door. It extends to your daily life, including when you are traveling on public roads. The Fourth Amendment protects you against unreasonable searches and seizures. Most people focus on the word searches when they hear that, but the word seizures is just as important. A seizure in legal terms means the government taking your property, your car, your wallet, your firearm. If law enforcement takes something from you without proper legal justification, that is an unreasonable seizure. It violates the Fourth Amendment. So here is the conflict. If police can take your legally owned firearm during any traffic stop, regardless of whether there is any evidence of a crime, then what does the Second Amendment actually mean in practice? Think about that. A right that can be suspended any time an officer decides he is uncomfortable is not really a right. It is a permission. And permissions can be revoked at any time for any reason. For decades, these two rights coexisted in a fragile balance. But as more citizens began legally carrying firearms in their vehicles, a dangerous trend emerged in lower courts. Courts began adopting a legal theory that said this: the moment a firearm is disclosed during a traffic stop, the nature of that stop fundamentally changes. Because of a perceived safety concern, officers gained what amounted to automatic authority to conduct warrantless searches of the vehicle, even when the firearm was completely legal, properly permitted, and safely secured. Think about how terrifying that logic is. If exercising your Second Amendment right to carry a legal firearm automatically strips away your Fourth Amendment right to be free from warrantless searches, then your rights are not rights at all. They become temporary permissions that cancel each other out. You would be forced to choose between defending your life or keeping your privacy. And here is the part that made it even worse. The system was penalizing honesty. The gun owner who disclosed his weapon openly and cooperatively was handing officers the legal key to search his vehicle without a warrant. Meanwhile, the person who concealed or lied about their weapon benefited from traditional Fourth Amendment protections. The law was rewarding dishonesty and punishing compliance. To fully understand why the Supreme Court had to step in, you need to know a specific legal rule that police officers have used for decades: the automobile exception. Under standard Fourth Amendment rules, if the government wants to search your home or your personal belongings, they need a signed warrant from a judge. But back in 1925, during the Prohibition era, the Supreme Court created an exception specifically for vehicles. The reasoning was practical. Cars are mobile. If an officer observes evidence of a crime inside a vehicle on the side of the road and has to leave to get a warrant from a judge, the car and everything inside it could be driven away before he returns. So the court ruled that police can search a vehicle without a warrant if they have what the law calls probable cause: concrete, objective evidence pointing to actual criminal activity, not a hunch, not a feeling, actual evidence of an actual crime. For example, if an officer pulls you over and sees illegal drugs sitting openly on your passenger seat, that is probable cause. If blood is dripping from a trunk, that is probable cause. These are specific, visible, objective indicators of criminal activity. Where the system went completely off the rails was when lower courts began stretching this automobile exception to include the mere presence of a legal firearm. Courts were ruling that because guns are inherently dangerous, knowing one was in the vehicle created immediate probable cause to search the rest of the car to see if other illegal items were hidden away. The Supreme Court looked directly at that argument and shut it down. The automobile exception still exists, but it requires actual evidence of a crime, not the presence of a constitutionally protected, legally permitted item. Carrying a gun in compliance with state law is not a crime. Therefore, a legal gun cannot serve as the probable cause needed to trigger a warrantless search. Full stop. Now here's the part that almost no coverage of this ruling is actually addressing, and I want you to pay very close attention because this is what separates this ruling from every other Second Amendment case you have heard about. There is a legal doctrine called the community caretaking exception. Here is how it works. For years, courts have allowed police officers to take certain actions: detaining someone, taking possession of items, searching a property, without a warrant and without probable cause, under the argument that they were acting not as law enforcement officers conducting a criminal investigation, but as community caretakers responding to a public safety concern. Two completely different legal standards, two completely different sets of rules. When an officer is conducting a criminal investigation, your Fourth Amendment protections are fully engaged, but when that same officer says he is acting as a community caretaker responding to a safety situation, the legal bar drops significantly. Some law enforcement agencies were deliberately using this doctrine as a backdoor, specifically in traffic stops involving firearms. The logic went like this: we are not investigating you for a crime. We are not searching your vehicle because we suspect you of anything illegal. We are simply responding to a community safety situation created by the presence of a firearm. Different legal category, different rules. And actual law enforcement training programs were built around this strategy, real materials given to real officers telling them, if you encounter a legally armed driver and want more legal latitude than a standard stop allows, frame the encounter as a community caretaking situation. The Supreme Court looked directly at those training programs and said no. An officer's subjective discomfort with someone exercising a constitutional right is not a public safety emergency. It does not lower the legal standard. It does not grant expanded authority over a legal gun owner. If you were ever stopped, disarmed, or had your vehicle searched while a legal gun owner, and the officer's justification was framed around officer safety or community caretaking with no other independent basis, this ruling speaks directly to your situation. Talk to an attorney. So what exactly did 9 justices unanimously decide? Let me break this down in plain English. Finding 1. A legally owned firearm is not probable cause, not for an extended stop, not for a vehicle search, not for the seizure of your personal property. If you have the correct permits, you are in a state where your carry is lawful and you are not a prohibited person, then the presence of that firearm alone cannot be used as the legal foundation to expand a routine traffic stop into something bigger. The reason the officer pulled you over, the rolling stop, the broken tail light, the expired sticker, defines the scope of that stop. The officer addresses that reason and then the stop ends. He cannot use the fact that you are legally carrying to pivot that stop into a fishing expedition. He needs something independent, something that constitutes actual probable cause of actual criminal activity. A legal gun in the hands of a legal gun owner is not that thing. Finding 2. The court addressed disarmament directly. Officers do have limited authority to take reasonable precautions during a traffic stop. If there is a genuine, specific, articulable safety concern, an officer can temporarily secure a firearm. Temporarily. But here's what the court made crystal clear. That authority has strict limits. It is time-limited and scope-limited. What an officer cannot do is take your firearm and use that act of disarmament as a pressure tool, as a way to extend the stop, call for backup, and coerce cooperation with an investigation that has no legal basis. The gun cannot be the lever that turns a 2-minute stop into a 45-minute ordeal, while additional units arrive and your vehicle gets searched without cause. Finding 3. And this is the one I want you to sit with. The court reaffirmed that constitutional rights do not cancel each other out. Your Second Amendment rights and your Fourth Amendment rights coexist. They have always coexisted. They were written to coexist. Any legal doctrine, any police training program, any court ruling, any department policy that treats these two rights as being in conflict, where exercising one means surrendering the other, is fundamentally and constitutionally wrong. 9 justices, 0 dissent. That is the law of the land. Let us translate that ruling into the practical reality of what happens at your car window. What officers can still legally do during a traffic stop? They can order you out of the vehicle. That authority is long-standing, and this ruling does not change it. They can ask for your driver's license, registration, and concealed carry permit if your state requires it. They can perform a visual check of areas in plain view through the window. And if an officer can point to a specific, objective, articulable safety concern, not general discomfort, but a concrete, nameable reason, he can temporarily secure your firearm for the duration of the stop. What officers can no longer do? They cannot conduct a full vehicle search based solely on the presence of a legal firearm. They cannot treat your honest disclosure of a permitted weapon as probable cause or as evidence of suspicious behavior. They cannot reach into your center console, open your glove box, pop your trunk, or dig through your personal bags without independent justification beyond the gun. They cannot use your legal firearm as the reason to extend a broken tail light stop into a prolonged encounter with multiple responding units. And they cannot invoke community caretaking or officer safety as an open-ended exception to override your Fourth Amendment protections simply because you are legally armed. Now I am going to do something a lot of channels in this space do not do. I'm going to tell you exactly where this ruling does not protect you, because giving you incomplete information is not helping you. It is setting you up for a false sense of security that could get you into serious trouble. The ruling does not protect prohibited persons. If you are legally barred from owning a firearm, felony conviction, domestic violence misdemeanor, certain mental health adjudications, none of this applies to you. If an officer has reason to believe you are a prohibited person in possession of a firearm, that belief constitutes probable cause the moment he knows it. This ruling protects legal gun ownership. If your ownership is not legal, this ruling is not your shield. The ruling does not erase other evidence. If there is drug paraphernalia in plain view, an open container, the smell of marijuana in a state where it remains illegal, or any other independent factor that gives the officer reasonable suspicion of separate criminal activity, the stop can expand to address those factors. The gun does not protect you from the consequences of unrelated illegal activity. The ruling does not prevent courts from looking at the whole picture. If you are making furtive movements, giving contradictory answers, reaching frantically under your seats, or showing behavior that a trained officer can specifically articulate as suspicious ACE, a court will evaluate the totality of circumstances. The gun becomes one data point in a larger picture. The ruling says the gun alone is not enough. It does not say the gun combined with a pattern of other indicators cannot justify further investigation. The ruling also does not solve complex state law issues. In several states with restrictive carry laws, California, New York, New Jersey, Maryland, Hawaii among them, the interaction between this federal ruling and specific state statutes is complicated. Minor technical violations in those jurisdictions can create their own independent probable cause that has nothing to do with this ruling. Crossing a state line with a firearm can instantly change your legal status from a compliant carrier to a non-compliant driver. Know your state. Know what your permit covers and what it does not. Know the laws in every state you drive through. And here is the most important limitation of all. This ruling gives you rights. It does not guarantee that those rights are respected in real time at your car window by every officer in every department in America. There are over 18,000 separate law enforcement agencies in this country, federal agencies, county sheriff departments, small municipal police forces. Updating training manuals, briefing officers, and retraining street-level personnel takes months and often years. There will be officers who do not know this ruling exists. There will be departments that have not updated their training. There will be situations where an officer pushes beyond what the law allows because he has never been told otherwise. Your job at the scene is not to educate him. Your job at the scene is to stay safe, comply with lawful orders, and give your attorney the foundation he needs to fight for you later. Here's exactly what you do the next time you are pulled over while legally carrying. Learn these steps. They matter. Step 1. Immediate response. The moment you see the lights, turn down your music, slow down, pull over safely to the right, and turn off your engine. If it is nighttime, turn on your overhead interior light. Place both hands at the 10 and 2 position on your steering wheel and leave them there. Do not reach for anything, not your license, not your permit, not your phone, until the officer is at your window and tells you what he needs. Your first impression in these encounters matters enormously. A calm, controlled, visible hands response sets the tone for everything that follows. Step 2. Disclose properly. Some states have mandatory duty to inform laws. Know your state law before you carry, because the obligation differs dramatically by jurisdiction. Whether required or not, if you choose to disclose, and many experienced defense attorneys recommend that you do it clearly, calmly, and early. Something like, "Officer, I want you to know I have a valid concealed carry permit and I am carrying a firearm holstered on my right hip. How would you like me to proceed? Clear, specific, non-threatening, not a confession, a disclosure, and critically, do not reach toward the firearm at any point while speaking." Step 3. Know your consent rights. If the officer asks to search your vehicle and he does not have a warrant and you do not believe he has legitimate independent probable cause, you have the right to decline. Say it politely and only once. "Officer, I do not consent to searches." That is it. No argument, no quoting Supreme Court cases at the side of the road, no escalation. Just that sentence, delivered calmly for the record. Body cameras and dash cams are almost certainly running. Step 4. If they search anyway. Do not physically resist under any circumstances. Comply with every lawful physical order. But speak clearly for the camera. "I am complying with your instructions, but I do not consent to this search." Let the officer proceed. Your attorney will address the legality of that search inside a courtroom where it belongs, not on the side of a road. Step 5. Document everything immediately. The moment you are free to leave, pull out your phone or a notepad. Write down the officer's name, badge number, department, patrol vehicle number, exact time, exact location, and the precise sequence of events. Write down the exact words the officer used to justify extending the stop or conducting the search. Write down how long you were detained and what was taken. Record a voice memo. If your vehicle has dashcam footage, preserve it immediately before it overwrites. This documentation is the foundation of every legal challenge that follows. Step 6. Get an attorney immediately, not eventually, immediately. If you believe your rights were violated during a traffic stop, if your vehicle was searched without consent, without a warrant, and without independent probable cause, and the only justification offered was your legal firearm, you have a Supreme Court ruling backing your position. But use it through qualified legal representation, not through an argument at the side of the road. The knowledge is your first line of defense. A real attorney is your second. Let me pull everything together because I know that was a significant amount of information and I want to make sure you leave with the things that actually matter. First, the Supreme Court ruled 9-0 that a legally owned firearm in your vehicle does not give police automatic authority to extend your traffic stop, seize your property without cause, or search your vehicle without independent probable cause. You do not surrender your Fourth Amendment rights by exercising your Second Amendment rights. Both exist. Both apply. They were written to apply simultaneously. Any legal doctrine, any training program, any court ruling that treats them as being in conflict is constitutionally wrong. That is now settled at the highest level of the American legal system. Second, the community caretaking doctrine, which some departments were using as a backdoor to expand their authority over legally armed drivers, has been explicitly rejected by this ruling. Officer discomfort with lawful gun ownership is not a public safety emergency. It does not change the legal standard. If you have ever been stopped, disarmed, or had your vehicle searched as a legal gun owner, and the officer's only stated justification was safety or community caretaking, talk to an attorney about what this ruling means for your situation. Third, knowing this ruling exists is only the beginning. The other half of protecting yourself is knowing how to behave in a real encounter, calmly, legally, and strategically, in a way that preserves your rights and gives your attorney the tools he needs if it ever comes to that. Comply physically at all times. State your non-consent clearly for the record. Document everything the moment you are free, and get legal representation immediately if you believe your rights were violated. Here is what is coming next on this channel, and I'm telling you directly, subscribe before this drops because you need this information. I am building a video specifically on the 5 states where carrying in a vehicle is the most complicated right now. 5 states where legal, licensed, fully compliant gun owners are getting charged with crimes not because they broke the law, but because the law is written in a way that creates invisible traps for people who do not know exactly where every line is. I will tell you which states they are, what the specific traps look like, and exactly how to avoid them. One of those states is going to surprise you. And if you ever drive across state lines, for work, for family, for hunting season, this is not optional information. It is protection. Subscribe right now, turn on notifications, and you will be ready when it drops. If this breakdown helped you understand something you did not fully know before, share it with one other gun owner in your life. I guarantee there are people in your circle who carry every day and have no idea this ruling even exists. The information only protects people who have it. One final note before you go. Everything covered in this video is educational information to help you understand your constitutional rights and how the courts have interpreted them. It is not legal advice for your specific situation, and it never can be. Every state has different laws, every traffic stop has different facts, and if you are facing a real legal challenge, a search, an arrest, a charge, you need a qualified attorney. This channel gives you the knowledge, a real attorney gives you the representation. Know the difference and use both. Stay safe, stay legal, stay informed.